Welcome back to Law and Crime Trial Network. I'm your host, Brian Buckmire, here again with Mike. Now, just to continue, we are still following the Kellen Winslow case. We're currently on break again. That is the case of the former NFL star who was accused of raping 2 women in 2018, 1 in 2003, and indecent exposure to 2 women. All 5 Jane Does, as they've called, have been testifying. I believe the prosecution is still in their case, and we'll hear more testimony from that side before the defense puts on their case. We are also following the Timothy Jones case, which is still live. Again, Timothy Jones is being accused of murdering 5 of his children, ages 8 to 1, being alleged to have beaten to death 1 and then strangling the other 4. But we're still on with the McStay murder case. It's been going on for a long time, and based on what we're hearing about how they're deliberating with the case, we might be here for some time. Again, the McStay case is the murder for money, where they're accusing Chase Merritt of killing the entire McStay family. Now, we do have some information about the closing arguments that we heard from prosecution. There's been a lot of drama. Let's take a look first at the prosecution's closing. You have at least the initial arguments, because again, don't forget, there's a rebuttal for the prosecution afterwards, and that's where kind of the drama came in. But Francey, I'll come to you first. As we're listening to the defense's closing arguments, before we get to that drama from the rebuttal, the defense attorney sounds kind of right. And maybe, I know that Mike and I have talked to, and as he said, it was dripping in sarcasm, which I think is a way that we both defend cases, but he's kind of right. There's not a lot about the actual murder, just a lot about the motive, which kind of gets a little hairy in the end.
Well, you're right, Brian. I mean, there is a lot of sympathy that the prosecution is trying to evoke. I don't think, though, it's for a bad reason. I think it's because prosecutors have an obligation and a need to prove to the jury that there were real human beings here, because they're the ones that aren't in the courtroom. The defendant is in the courtroom, and he often gets a chance to show that he's empathetic, that he cries when he sees dead bodies, or that he's not a monster. And I think the prosecution is obliged to show the same kind of thing on the opposite side for the victims. But you're right, there is not a lot of direct evidence in this case against the defendant.
Yeah, and Mike, to you, where Francey's right, obligation to the victims. Whenever there's a murder case, there's absolutely victims. The question is whether or not Merritt is the one who killed them. So there's sympathy there, but is it too much sympathy and not enough facts? Like, there's got to be a line, right?
I don't agree with that. I don't agree there is an obligation. I think the obligation is actually the jury charges universally, and I know definitely in New Jersey and New York, is they speak about you're not to allow emotion to come into your deliberation when you're instructing the jury. And I think this defense attorney is rightfully rebutting that, saying this is all they've got. I mean, you can't evoke emotion toward the defendant until you can prove the defendant was the cause of the pain that happened. And I think, I don't think there's an obligation by the state. Actually, I think there's an obligation to tone down the emotion in these cases when the fact is so weak, the facts are so weak, and the proofs are so weak, because you don't want that to override the deliberation in their factual findings.
I'm probably sitting in the fence between the two of you, and I agree with both your points, because I think, Mike, you're talking to the law, and I agree. New York, New Jersey, most states say that sympathy cannot be brought in, but we know that sometimes sympathy wins the day. And so while there are things that legally we can't do, I mean, I'm guilty of it. I've pulled on a few heartstrings here or there to try to convey my information. But I guess for me here is, if there's no facts grounded in who did this, and then we know in the rebuttal it almost falls apart because they changed their whole theory, I mean, we'll send this to you, Francey. What are we left to believe when you hear one theory of prosecution 1 minute, and then literally an hour or 2 later you hear another theory? From a legal standpoint and a factual standpoint and a credibility standpoint, it seems like this case is unraveling for the prosecution.
Yeah, Brian, that's a great point. I mean, that is extremely problematic. You stick with your theme from start to finish because you have faith in your case and you have faith in the evidence, and changing your theories mid-stride or even at the very end of the case, which it appears they may be doing here, suggests to me that they understand that they have not proved their case and they're grasping at straws. And that's why I've said all along, although my sympathies are almost always with prosecution, as I think everybody knows, all along I've said I don't understand why this is a death penalty case. I don't understand why it's taken this long to try this case. It's not that complicated, and it's been long and drawn out, and I think, unfortunately, the state's going to lose.
Yeah, and we're going to continue to follow this case and probably look at some of the rebuttal as well, and to fully evaluate how they might have misstepped in taking strides to this case after this break. So at least for us here at the Law&Crime Trial Network, we're kind of confused as to how this witness furthers the case. Francey, I know that you were commenting during the break, and I agree with you. How does this help?
Well, this helps the state, I mean, for sure. And this helps establish his culpability. And I've said in these cases where you have parents killing their children, the jury expects to see a slavering, crazy person before they are going to let someone off on insanity for the heinous act of killing children like this. And this witness might as well have been called by the state because she helped their case, and she certainly didn't help the defense.
Yeah. Mike, I understand that maybe some of our exes might think we're crazy, and maybe that might be the defense that they're trying to go with, that the ex is going to think that the former boyfriend is crazy. But like you were saying in the break, you put on an expert and then you kind of walk away. What's with the ex-girlfriend and all this background noise?
I am baffled by this because you put the expert on. I mean, all this is saying is that you want an insanity defense to say that these very specific victims were the only people ever put in danger at this very specific time because somebody couldn't appreciate their very specific act at that time. Putting on all these other people who thought he was crazy, violent, and all these other things is telling the jury, you can't let this guy walk the streets because he's mean and he's violent to everyone, and anything will set him off. I think this is really amazing. I don't understand why people feel that more is good in putting on a defense.
Yeah, to Francey's point, this seems like a prosecution's witness, but you wanted the doctor's testimony, we'll give it to you. Let's take a listen. So again, we're left to question, what is the defense doing? Why are they putting on this witness? Francey, I know that we saw an earlier clip that this court-appointed psychiatrist said he could definitely appreciate what was going on, and now we're hearing this testimony. It begs the question, where is the defense attorney picking up his paychecks?
Well, I think here, Brian, the defense is just trying to do one thing, and that is save their client's life. They're obviously not going to, they're really not even trying to say he didn't do it. So they're trying to save his life by throwing in as many things that might get the jury to feel just that little tiny ounce of sympathy for the defendant that they won't agree to the death penalty. Remember, they only have to get one juror to agree that he should not be executed, and then the defendant will not get the death penalty. So their task, their burden here isn't all that high. And I think saying it was all a drug-induced haze or there's something slightly wrong with him, there's the word psychosis being thrown around, may be enough to generate that sympathy.
Yeah. And Mike, I hear what Francey's saying, but a little bit of sympathy might not go far enough when you're accused of killing 5 of your kids. I'm not sure that's the route here. How do you see that?
I think this case is so horrifying, so terrible that the defense is trying to throw everything they can against the wall and see what will stick. And when Francey was talking, it really crystallized it much better as to why they are putting it on, because I wasn't understanding it, but Francey sort of made a great point in that maybe they're hoping one thing will stick. But based on that, if that's what you're hoping for, I would think they would go a little further with the expert and have him say something like, this person was in these induced hazes of, narcotics, opioids, and whatever, but there is some hope that he could be rehabilitated, that he can, have some treatment, things of that nature. Just leaving it at that, I think, will not really make a jury feel comfortable about letting him walk away or not giving him a death penalty.
Exactly. A little bit more probably was needed. But we're going to continue this case and others after this break here on Law&Crime Trial Network. And we've been following other cases, specifically the Kellen Winslow Jr. case, where we've seen where multiple victims make it that much more harder, that much more difficult to climb that mountain to get out of the conviction or jail time. With the Kellen Winslow case, we are still alive, and so we're going to continue to watch some of the alleged Jane Does who testify. We're going to recap and look at actually Jane Doe number 4 who was on the stand. Again, that's Jane Doe number 4 talking about the consensual encounter that she had with Kellen Winslow back in 2003 when she was 17 and he was 19. Francey, to you, I guess they're building some sort of case to say it was consensual at one point, but it was not at the other. I mean, we all know that you can have a consensual relationship one day and then it be rape the next. So what's the point of bringing it up?
Well, it's interesting. I mean, one of those questions was a little bit disturbing, and I think it shows a little bit of the point of this examination, and that was asking her if she, quote, hooked up with someone you just met. And there was pure and simple slut shaming. There's no doubt that they are trying to dirty her in the eyes of the jury with that one simple question and answer. But I think the point is that they want to just raise in the minds of the jury that this woman was perfectly happy to have sex with him at one point, and so now she's probably making it up in order to get notoriety or money or a civil settlement. I mean, there's no doubt that that'll be part of the thrust of their argument.
Yeah, and it's interesting. And I agree with you. There's probably going to be something in summation because I believe she had said that she had come forward based on, as a lot of victims, or in this case, because we have a conviction, a lot of alleged victims come up and say, I would not have spoken up until another woman had done so. They find the strength because someone else has spoken up, because oftentimes, as a society, they go through a very tough rigor of having to prove these facts against their alleged rapist. But I can hear the defense already maybe starting to formulate, he's about to get drafted to the NFL. You knew he was a big-time football player. There was opportunity for you to kind of make some money, and you only came out after the fact. I mean, it's going to be the same story we hear all the time, Mike, but how's it going to play out with the jury?
I always think that's a very difficult road to travel. Before I saw the light and came on the defense side, I had prosecuted sex crimes cases. And the best thing for a prosecutor to say is, and I think a jury really digs in and understands, is, like, do you think this person came and exposed themselves to you about this horrible event? Do you think you really put a price tag on that? You had a chance to observe the way this person reacted to these questions. The only reason they're coming here is because it's true, and that's all they're gaining. And I think that's a very, very difficult obstacle for any defense attorney to get around, especially when the witnesses are credible. And she seems pretty credible, pretty composed. And the very fact is, if you were going to come out, wouldn't you come out when he was going to start getting paid, not wait all this time?
Yeah, there's no money in it now. Who knows Kellen Winslow Jr. now? The time where he had the pro bono nod, that would have been the time to come out. So I agree with you. I think the prosecution, if they do it well, will have a great time of being able to prove these allegations correct. Now let's listen to the same Jane Doe who talked about the actual sexual violence in her encounter. Some very heartbreaking testimony you hear there. We were talking in the break, Francey. I think that I understand the arguments we've had here in the past that Jane Doe number 1 has some identification issues, Jane Doe number 2, Jane Doe number 3, but this is the Jane Doe that I think really hammers it home for the prosecution, really hurts them.
She does, Brian. This testimony was devastating. This woman is not an actress. She is clearly emotional in recalling these events that happened an awfully long time ago, and she describes them in excruciating detail. The emotional impact of this testimony, in my opinion, is enough to convict him in this case.
Yeah, and I know that we were talking about there may be an impetus for her to testify because there might be money in it, and the defense attorney might bring that up as well. But Mike, you brought up a point, and we're still trying to look into it, but the statute of limitation in California might not allow her to charge civilly, so there might not be any motive for her other than to say this is the truth and this is a dangerous man. What would you say about that?
I think that's an excellent point. I mean, these events happened in 2003. My understanding is, on the quick research of it, in California, the civil statute of limitations is 2 years, and it can only be extended if you have an argument that the that the person didn't come to the forefront, they were suppressing it and didn't become aware of it until later on in life. However, that doesn't seem to be the point here, because she's already has people testifying that she told them back in 2003. So around that time, she confided in people that she was raped. So she really has no ability to collect on any civil case because the statute of limitations is run. And I think that this is a really, really effective witness. And this is really going to destroy that whole argument. And it will roll over and spill over onto other defendants when they try to raise that.
Exactly. Now we're going to hear more from this case and others when we come back after this break.